number, Aadhaar, to a resident of India primarily to serve as a proof of identity, which could be used for transfer of benefits, etc. In 2012, a retired judge, Justice Puttaswamy, he filed a writ petition under Article 32 before the Supreme Court, challenging the constitutional validity of the Aadhaar project. You may recall that earlier in MP Sharma and Kharak Singh, Supreme Court had said that there is no such right called a right to privacy. It is not enumerated in the Constitution, and we can't read something into the Constitution which is not there. A 9-judge bench of the Supreme Court in the first Puttaswamy case, different judgments were, different opinions were given, but in the main opinion, the bench expressly overruled this MP Sharma and Kharak Singh and held that right to privacy is an intrinsic part of right to life and personal liberty under Article 21. A law which encroaches upon the right to privacy will have to withstand judicial scrutiny on the touchstone of Article 21. Any infringement of privacy must be by a law which is just, fair, and reasonable. Of course, right to privacy is not independent of other rights and freedoms guaranteed by Part 3 of the Constitution. It's an element of human dignity and is an inalienable natural right. The main opinion focused on the informational aspect of privacy, its connection with human dignity and autonomy, and rejected the argument that privacy is an elitist construct. Now, thereafter, in 2016, the Aadhaar Act came to be enacted, as it was felt by the Parliament that the Aadhaar project needed a statutory backing. So we now have the second Puttaswamy case. In this, the Constitution Bench of the Supreme Court upheld the constitutional validity of the Aadhaar Act, though certain provisions of the Act were struck down. Supreme Court held that use of Aadhaar for the purpose of welfare schemes was constitutional, as it could pass muster the triple test of legitimate state aim, necessity, and proportionality. Court also upheld linking of Aadhaar with PAN cards, but declared linking of Aadhaar to bank accounts as unconstitutional and disproportionate. A minority opinion was given. Justice Chandrachud disagreed with the majority. Justice Chandrachud, no doubt, is a great judge. In recent times, of course, controversy seems to surround him wherever he goes. Nonetheless, he is a great judge and would remain to be so. He stressed upon the incoherence between the biometric model deployed by Aadhaar and the right to anonymity of a citizen, focused on the right to anonymity. And he said that anonymity is central to a person's sense of freedom and autonomy.